Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the U.S. New York SHIELD Act. The SHIELD Act went into full effect in March of 2020. It is an update of a 2005 data breach notification law in the state of New York. In the U.S., all states currently, as of 2019, have a data breach notification law. However, those laws are different in every state. The reporting requirements are different in every state. And this is one of the first things that people think about when they think that the U.S. should have a federal data privacy law, to at least try to harmonize the data breach notification laws in each state. However, although the state of California was the first state in the U.S. to have data breach notification laws, New York enacted their first data breach notification law in 2005. However, New York, being a forefront type of state and a very influential state, had decided to update their data breach notification law to expand the definition of things like personal data. So combinations of things like maybe a username, a password, a security question may be considered personal data in New York now under these laws. The law is really meant to beef up cybersecurity and the way that companies protect data that they're given of personal people. In terms of things like determining thresholds for who this applies to, this law applies to any company that holds personal data of individuals in New York. They don't have to do business in the state of New York. That's part of the expanded definition. As I said, the categories of personal data are more expanded for lots of different types of data. So a combination, for example, someone's name, address, and their email address may be considered personal data under this law. There is no limit in terms of the type of company or size of company that is impacted by this law. Also, this law does not have a private right of action, meaning that individual consumers cannot sue, but the state attorney general can force companies to comply or either fine them up to $250,000 depending on the incidents and circumstances. This law really forces or really pushes companies to have forethought about cybersecurity. Things like making sure they have the technology, they have the people and process in place, and also making sure administratively they can manage cybersecurity and do it in a proactive manner. If a breach were to happen, there are a set of circumstances in which the New York AG wants to be notified. One reporting requirement also has to do with also naming a breach of maybe something that may happen internally in the company, not necessarily even things that are external to the company. So any company that has data of anyone in the state of New York that is considered personal data under this law needs to really pay attention to the SHIELD Act. The SHIELD Act and the state of New York are very influential for other states, so it's possible that other states may take the lead from New York and also update their data breach notification laws. But again, this is a new law that's fully enacted now. People are going to be waiting to see what type of precedents that will be set under this law. And how people will change the way that they handle data, the privacy of data, and the protection of data of people who are in the state of New York. Thank you.